When Megan was assembling this panel some time ago, she said that one of the things that NASPO members have been asking for a long time is, can you get 4 white guys? And even better, could you get 4 guys with Germanic last names that are unpronounceable? That would be perfect. So you know, we did what we could. We're here. So, but I'm just really pleased to be with my panel here today. I think 10 years ago was the first time I heard the word unicorn used, and now it's become a cliche. But we do have a couple of unicorns here who are truly experts both in state and procurement, state and federal procurement, which is really the topic today. And then Steve Schooner needs no introduction. He's been here many times before. I had the chance to speak to you 3 years ago, and I'll mention it once before. Some of you might have attended the ABA virtual conference last month, but I mentioned it there for the first time. But I hope to create a center at the University of Dayton School of Law for the study of state and local procurement. I think it's a subject that's just not studied enough. So I'm just thrilled to be here. Thank you. I'm just thrilled to be here with this panel of experts and to learn from them today and learn from you. As you can imagine, there are a lot of different directions we could go with this conversation today. So we're very interested. We framed our conversation today around some informal polling that had been done in NASPO about what are the biggest issues that are facing state procurement officers. So that's where we're going to try and focus our attention. But as you can imagine, there are a lot of different directions we could go. So I'm going to start by kind of framing our discussion. And as I'm doing that, I want you to kind of think about that, because what we're interested in, maybe even more than what we're going to talk about as a panel, is what are your questions for us? So I'm going to try and frame this in a way that kind of limits the types of questions you might ask, because like I said, we could go in a lot of different directions here, and we want to try and stay focused on the reason why we're here. So, some stage setting. Like I said, this came from some informal polling when we talked to, or NASPO talked to some of the people you work for and with just recently, and asked what are the most pressing issues that you're facing. And one of the things that was mentioned was the conflict between state and federal law. Maybe that's obvious to everyone in this room. It's a new issue that we're facing. Usually we're used to thinking about just one jurisdiction at a time, and for the first time for a lot of us, we're having to think about conflicts between state and federal laws, or at least more than we ever had in the past. Now, just to limit your expectations a little bit here, to adjust your expectations, this panel is composed of experts in government contracts law. Most of us are not talking about constitutional laws or conflict of laws on a daily basis. So please manage your expectations a little bit there. So we're doing our best with what is in some ways unfamiliar terrain for us as well. And lest we, again, with managing your expectations, we cannot provide practical advice on all 50 states. We don't purport to be experts in all 50 states, but we can help issue spot today. And I think we can help maybe provide some thoughts, some discussion points about solutions and a way ahead. And we obviously could make this a very political commentary today, and that's something we're going to try and refrain from. Our purpose today is just the facts, just to talk about what we know, not what we feel about some of these things. So we're going to try and keep it narrower in that respect. So with that, we'll jump into our questions, and we're still going to be kind of defining our terms. I had a long monologue there, so I apologize. The rest of the time will really be devoted to the panel. So to start off, Eric, if I could turn to you. Could you give us a primer? The other Eric actually gave us a primer just a moment ago about the levels of law. Could you give us a primer on the different levels of law?
Right. Thank you. I'm Eric Weisenberger. Thank you for having me here today. I'm excited to be here. And so what we wanted to do is just start out by talking about we're going to be using a lot of terms of art today, and we didn't want those to get confused or lead to anyone misunderstanding what we're talking about today. So In very basic terms, there are different levels of authority among the laws, right? Obviously, at the top is the Constitution, supreme law of the land, as we all know. But below that is where it gets a little muddier, right? So you begin with the statutes. Statutes, as you all, hopefully everybody, and this isn't a dated reference, learned from I'm Just a Bill, Schoolhouse Rock. That's that is legislation developed by Congress, passed by Congress. And as Eric mentioned in the previous half hour, legislation often sets a framework, right? A statutory framework for different government programs. And where those frameworks are implemented is often through regulations. And regulations are the next step down, right? Regulations are implemented by agencies through a lengthy process, often through notice and comment process, which hopefully you haven't dealt too much with. And I understand the pain that can go through, but regulations are more of the implementing day-to-day laws as opposed to the statutory frameworks that sit above them. And the regulatory framework that many of us deal with would be the Federal Acquisition Regulation, the FAR. You'll hear much about that as we go. But the FAR, which is going through the regulatory rewrite as we speak right now, is the federal edition of many state procurement codes and state procurement regulations. Next up is sub-regulatory guidance. An example of sub-regulatory guidance would be a procurement manual or memoranda issued by agencies. This is an agency saying, hey, this is our day-to-day policy implementing many of our regulations, but you can't use, for example, sub-regulatory guidance to override regulations, statutes, et cetera. And then the last one that I just wanted to mention, because it's been in the news quite a bit, would be executive orders. Executive orders are not immediately law, of course, but they direct agencies to do different things, right? So an example would be the executive order directing the FAR rewrite, the revolutionary FAR overhaul, as it's called. So the executive order says agencies and agency heads, FAR Council, we need you to do this overhaul. Agency then takes it and starts working on the rewriting the regulatory framework. So it's, we're coming full circle because the FAR overhaul, of course, is designed, or stated design is to strip it down to statutory minimums, right? And why can't the FAR rewrite override the statutory minimums? Because the statutes are higher in authority than the regulations. So that's just a quick. I'm not going to spend an entire hour talking about the authority levels here, but hopefully that contextualizes some of our points today.
Thank you very much. Aaron, we've already mentioned conflicts of laws, but maybe you could give us all a refresher on what that means and what we're talking about in this panel.
So first of all, we're not really talking about conflict of law the way that concept is often used as a term of art. And I'll tell you what we're also not talking about, which is what I ran off and when I was asked to maybe join this panel, and I thought of all these great ideas, and I listed them all, and I sent them all to everybody, which was, we're not just talking about differences. We're not just talking about, oh, well, at the state level, we don't have solicitation pre-award protests, but at the federal level, we do. We're not talking about that either. So you'll never have to see or hear about that email from me again. But what we are talking about is where these levels of laws, to some degree, are giving you direction, sometimes vague, sometimes specific, that is counter to what your own state laws, or if you're at the local level, local ordinances tell you you need to be doing. And so you're being pulled in two different directions, and you have to figure out how to manage that. So that's what we're mostly talking about. And just to add on to what Eric said, I think about sort of this line. If it's the Constitution or it's a statute, that can impact and create conflicts for you in and of itself. If it's below that line, if it's a regulation, that's typically telling an agency what they have to do. So a federal regulation in and of itself won't or shouldn't create a conflict, nor should an executive order or agency memos. But that doesn't mean they're not relevant. There's still the hook. If there's the hook above, like a statute, or another hook, which we haven't really talked about yet, which is a contract. So a procurement contract between a federal agency and a state, or more often a grant agreement, that can bring in some of these lower level guidance or regulations from the federal side and make them requirements and create conflicts for states.
Excellent. Steve, we're obviously in a period of rapid change. What are the most significant changes going on in Washington, D.C., and that are affecting state procurement?
So first, let me say thanks for being here, but in response to the question in terms of what's going on in D.C., I am reminded of the popular movie, Everything, Everywhere, All at Once. As the old guy in the room, and let me be clear, I lived through the introduction and implementation of the Federal Acquisition Regulation, which was promulgated on April Fool's Day, 1984. There is no precedent for the pace and the depth and diversity of the change we're going through right now. So we'll talk more about some of these later, and we hope you'll tell us which ones you're most interested in. But let me try to limit it to 10 things going on right now. Some of you may know the federal government is shut down. We have a budgetary crisis going on. Next, everything that we understood about federalism throughout our professional careers is going out the window. And things that you've expected the federal government to do throughout your careers are about to become state responsibilities, and that trend will continue for the foreseeable future. We heard a reference to the revolutionary FAR overhaul, which may not be revolutionary, but it is an overhaul, and it will generate primarily work for attorneys in the future. We are also seeing an unprecedented consolidation of purchasing authority at GSA. Historically, if you compare it to states and around the world, we are a decentralized or disaggregated model at the federal government. Agencies buy their own things. As that gets consolidated at GSA, there are going to be dramatic differences, particularly because they're not staffed for the work. You may or may not be following the micro-purchase threshold, but what used to be basically pocket change purchasing is now basically going to pull the bottom out of basically 90% of everything that we think is public procurement, and that trend will be jarring. The global trading community as we know it is collapsing before our eyes, and many of you are involved in the World Trade Organization Government Procurement Agreement. We have, in many ways, harmed ourselves with regard to the acquisition workforce. I'll talk more about that later as an opportunity for you. There's a couple of major technological issues going on right now. In addition to artificial intelligence, we just had, for the first time, a major initiative finally come to fruition with regard to cybersecurity, and that will lead to a lot of flow-down impacts on the firms you do business with. Only two more. Early this morning, we had a lot of discussion about procurement integrity. If there's one thing for you to know about ethics in public procurement, it's that procurement professionals and other government officials look up and around for cues of behavior. And you can make your own conclusions about what you see when you look up and around in Washington, D.C. right now. The last one, and I hate to end on a downer, but as my students know, I think there's no more significant issue in public procurement today, or the generational issue for your generation and beyond, not mine, is that the federal government and states, all governments, are going to have to do more in terms of sustainable procurement if we want to leave any kind of legacy for our children. The federal government is going backwards on that, inconsistent with the global change, and if we don't start soon and work faster on sustainable procurement, I have no good news for my children whatsoever. On that cheery note.
That's a lot to digest, Steve. Thank you. Aaron, lots of different directions we could go there. The canned question I had for you, as you know, is can you give the audience your perspective on how much of state procurement is being affected by the changes we're seeing at the federal level? But Steve also mentioned the centralization of procurement. I don't know if you want to comment specifically on that, or if you want to take up something else that he mentioned.
Well, when we were planning this out, we thought it'd be wrong to bar the doors and keep you all from running out when FSC made his comments. So I said I suggested that I'd be given an opportunity to give you a little perspective, which is that Well, let's take a step back for a minute. Most of what you do is not directly impacted by what the federal government does, and much of it is not even indirectly impacted by that. So, most of your jobs, most of the time, you're not going to be running into these conflicts that we're talking about. They'll be in the background, many of these big issues that Steve mentioned, but they're not going to impact your day-to-day or the day-to-day of your departments. Keep in mind, really, there are two ways that these conflicts can impact you. One is you're taking federal money or you're receiving federal money for what you're doing. You're all used to that. We're not really going to talk about, it's not really a conflict when you have strings attached to federal money and you have a state law that has, as many of them do, an exception clause that says this is the way we do it unless there's federal money and it's in conflict, and then we do what the feds say. That's not a conflict. And the other way is, those exceptional circumstances where federal law still imposes requirements on your procurement. An example might be for civil rights and anti-discrimination laws. That's an example. But most of the time, though, that's not your day-to-day. You're not worrying about, when we procure these services or these supplies, whether or not, we're violating the ADA. And if there's something new that's coming along, you have a process and you'll deal with that. And now I forgot what the specific one was that you were. Oh, the
centralized procurement. If you
right.
wanted to say a word about that.
Right. Just that. I guess this goes back to one of the two, which is the federal money, and which is that as the benefits of using a centralized marketplace in the federal government, increase, and I imagine many of you in your jobs, or at least colleagues of yours, do schedule buying through the GSA. There are going to be more and more benefits, more and more opportunities to purchase through that. But there will be this price of some new strings, some new legal requirements attached to that. At least that's the way things are going right now.
Thank you. Well, enough with our stage setting. Let's jump into our problem set, and kind of a lightning round here. A question for everyone on the panel, and we'll start with you, Eric, if that's okay. What are the primary issues? And I should warn you, this is a compound question. What are the primary issues for state procurement officers, and what's on the horizon for state procurement, given the rapid changes at the federal level?
Okay, thanks. So I'm going to talk a little bit about, because my day-to-day is from the contractor perspective, so I'll try to offer a little bit of the private sector perspective here and what my clients have been thinking about on a day-to-day basis. So, and I'll put this all, of course, in the hypothetical context because I can't talk about what we've been advising or what our clients have been doing, but the biggest conflict that we've been seeing, given the new changes at the federal level, are really with respect to affirmative action plans. That's been a hot button issue for our clients. So if you think about it this way, say you have a company that does business with states and does business with the federal government, takes in money from both. And the state at issue has affirmative action plan requirements, and those affirmative action plan requirements say that anybody who does X amount of dollars of business with the state must have an affirmative action plan in place, and that affirmative action plan must include some type of effort by the contractor to hire underrepresented individuals, and they have to document their progress with that and how often they're able to do it and things like that. Then in July, Attorney General Bondi issued a memorandum that talking about illegal discrimination with respect to federal dollars. And that memorandum says that where there is, in essence, it says quite a few things, but one of the things that it says is that there are, that it is an illegal discriminatory hiring practice to favor individuals from, for example, underrepresented groups. So if you're looking at it from that perspective, there is potential, and it all depends on the state, it all depends on what the particular laws are, and it depends on how this ends up being enforced by the federal government. There is potential for conflict between those two. And so what clients have been seeing and what contractors have been seeing is essentially, they're thinking about how they can satisfy both sets of requirements. And talking to state procurement officials, they're often not given, and this is in no way is this any sort of blame casting, because I think everybody is wrestling with these questions and is doing what they can with their information. It's difficult to find guidance either at the federal or state level about how to address that to the extent that anybody does see conflict between those two. So looking for guidance from the states, to the extent that you can help contractors work through those problems together, that I think would be greatly appreciated. But I completely understand that this is a difficult question to wrestle with, and is varies state by state on how you can actually address it. But is something that I'm seeing as probably the primary issue that I've heard about in recent days.
Thank you. Aaron, if we go to you, we'll give Steve the last word on these two questions.
So maybe one of the things to start with is, particularly since we were just talking about the future of the model procurement code, for all of you who have spent your careers being maybe, chafing at the federal government ignoring state and local procurement and maybe being a little bit arrogant about how central they were to the procurement process, it's a nice moment for you all to be laughing at the federal government. That's perfectly okay. But I just want to kind of emphasize three things which are already touched on. Aaron spoke about the grant money, but the reality is a lot of functions that you do have an underpinning that has a free, consistent flow of money coming from the federal government. The ones that come to mind for me, not just infrastructure, roads, research, but there's also going to be some other massive ones like healthcare and even food safety. I'm not so worried about air traffic yet, but the reality is the federal government isn't funding things that the public expects to have done. And I like to think of the acquisition cycle as one that begins with forecasting. And I think you're going to need to be telling the people in power in your legislatures and your governor's offices that you're going to need more money really soon to be doing things that the federal government has done for the duration of your lifetime. The other thing is, it's impossible at this point to see what the spin-off or the spillover is going to be with regard to your public universities and possibly relationships with your private universities. But I think if you haven't internalized how significant the impact is on universities and colleges, whatever you think it is, it's a factor of 3, maybe 10, particularly because so many universities in this country have become very, very accustomed to solving a lot of their budgetary problems by admitting full-paying, premium-paying non-U.S. students to subsidize many other things they do, and that siphon is drying up. So we have a lot of big changes here, and I think a lot of it's going to impact what you're going to be doing next year as well.
Thank you, Steve. Aaron, the next question was yours, and so I'll let you choose. Do you want to answer the next question, or do you want to take this one?
I'll segue into the next question
Sounds
about
good.
the biggest areas, but I just want to comment on two things Steve said. One, at least we know George Washington doesn't rely on foreign students at all. So that's good. And two, you heard it here, Steve guaranteed no problems with your flights home. They're all going to be great. So nothing to worry about there.
Thank you very much.
Yes. We thought it might be useful just to identify some subject matter areas where we're seeing a lot of these conflicts arising. And so I took a shot at listing some, trying to use as apolitical labels as I could. And some have already been alluded to by Eric, in terms of the affirmative action. That's where the rubber's hitting the road on DEI policies from the federal government and enforcement indications from the federal government that are going to be coming to states. And I guess one other general point before the specific list is that in addition to not having guidance, you don't have any court guidance yet. You don't have courts deciding at a state or local government level whether some practice violated one of these conflicts and violated a federal legal requirement that, as interpreted and enforced by the current administration. So that also leads to the uncertainty. The list here, you could kind of see they're all hot because, or most of them at least, because they reflect the most recent policy changes out of Washington. So they're the newest, and so you have the least guidance, the most abrupt changes. Some don't fit in that. I mean, cybersecurity is an issue that's been evolving for a long time, but that's one where, as the federal government is developing its requirements, that's one that you can't have effective requirements in a vacuum. So those are going to bleed into state and local government procurement. Privacy is another one that fits into that, where we know changes are coming. They've been coming, and to watch out for. DBEs, if we have time, I'll talk a little more about that later. But in particular, there's a good, interesting case study in what U.S. DOT and the state DOTs are having to do with the U.S. DOT Disadvantaged Businesses Entities program. And that's one where you see the hook coming from a statute, maybe, and then now regulations and then clearly a hook through the grant agreements that are impacting compliance at the state level with federal DOT-funded programs. And even if I imagine the vast majority in this room don't work at a DOT because they tend to have their own independent authority, but that's a good case study to see where things may be coming in your procurements as well. Some of the others I list, climate-related changes is another big one, and some social issue changes that are all areas where you need to be on higher alert, I would say, on making sure that when either there's a federal statute or a grant or a contract requirement, that you're keeping up with changes from the federal side about requirements to identify these conflicts or potential conflicts and address them.
And Steve, if with your permission, I'm going to skip ahead and skip the policy question, hold that one in reserve and see if we have time for it later. And I'm going to go to Eric. And I'm going to ask a slightly different question than the one that's on the screen. So from the perspective of a government contractor, what are the primary concerns and strategies for managing the risk of conflicting federal and state requirements?
So there are several, and this is, of course, a new area that has not been something. Well, this is an evolving area, I guess we can call it that, right? And for the reasons that we've been talking about today, of which there are many, as well as the revolutionary FAR overhaul, which we may be able to touch on a little bit today. But what I would say is that what contractors are dealing with and what they would find to be most helpful, in my experience, is just having productive conversations with state procurement officials through question and answer. And when in many procurements that I've seen, there's an opportunity for Q&A with the agency, right? And often contractors don't always ask the best questions. I think we can all recognize that. But then sometimes the answers are just confirmed or yes or something like that. And it can be helpful to use that type of, it can be helpful from the contractor perspective to use Q&A in the procurement system, use the Q&A as an opportunity to have a productive conversation about how to avoid issues like this. That's one way that maybe if contractors are able to ask the right questions, this can help develop a nice productive dialogue without violating blackout rules and things like that during the procurement process. But it's one among many, and it's a developing area that just keeping in close contact with your contractors, especially after an award is made and you're able to talk to the contractor in more detail, keeping the line open to say, hey, this is an issue that we're dealing with, this is an issue that we're seeing, how can we work together to make sure that we're all staying in compliance, and that there's no issue with, you maintaining, for example, your federal contracts, because, we don't want you to risk cutting off this contract early because it puts your federal dollars at risk, for example.
Thank you. Aaron, you had mentioned talking about DBE, but if you don't mind, we'll hold that one in reserve and see if we have questions from the group. And I'll go to Steve, and I wanted to ask you about if you could address the question of change and just generally, and change in the federal procurement system.
So this may not apply only to procurement, but I'm going to suggest this is the most important topic that we all have to deal with every day. I would call it critically important, or maybe an elephant in the room. I say this to you as someone who is maybe the old guy in the room. My last job before I came to GW, I was in the White House Policy Office, the Office of Federal Procurement Policy. And like my colleague Chris Hukins, who many of you know, I've been lucky enough in the last few decades to have worked in more than 40 countries and with international organizations all around the world. And the same mistake that we all make all the time is we think that changing rules matter. And rules have no impact whatsoever if we don't implement them. Or in other words, everything that we do in public procurement, it's about people, not rules. If you're totally bored with this discussion, if you got your phone handy, I'm going to encourage a little bit of reading. I recently published an article with my colleague Jessica Tillotman titled Institutional Amnesia and the Neglect of the Federal Acquisition Workforce. It talks about everything going on in DC, and it's the same mistake over and over again. Just like you heard 45 minutes of the rogues gallery of bad actors in public procurement this morning, we could do the exact same thing with government after government around the world saying, our procurement process sucks, let's change the rules. Let's not hire more people, let's not raise the credential level, let's not train them, and let's not incentivize them to do the things we want them to do and not do the things we don't want them to do. It doesn't work.
Let's just make their jobs harder by changing the rules on it.
Right, and there's nothing harder when you're trying to train and develop people than constantly destabilizing or confusing them. But the process of change management, the idea of sending clear message, this is what we care about, this is what we want you to do, this is what we want to prioritize. There's an entire related issue that one of the biggest mistakes we make in public procurement is we measure what's easy to measure and not what matters. We are the masters of transactional data. How much money we spent, where did we spend it? We don't do what the private sector does, which was ask the two fundamental questions. Did I get value for money? Was I satisfied with my purchase? Customer satisfaction is the coin of the realm, but that's not the way we're measured. If we want to actually improve our procurement systems, what we need to do is focus less on just churning the rules and more on getting the right people, training them, developing them, and incentivizing them to do the right thing, which is why it's wonderful that you're here so that we can have these conversations. And it reflects what an important role organizations like NASPO have to play, state after state, pounding that drum. Procurement is not about rules, it's about people. But if we don't have the right people and they don't know what they're supposed to do and they don't know what our governments and the public care about, we're never going to make our systems better.
Thank you, Steve. We're at 15 minutes, and we wanted to leave at least 10 minutes for questions, so we wanted to do a quick kind of a lightning round, maybe just a minute or two each on this last question. So Aaron, if it's okay, I'll start with you. From a practical perspective, what's one takeaway from this conversation, and one thing that's not on the slide? Are there any silver linings?
I'm trying not to steal Steve's silver lining, 'cause I don't remember. I'm going to incorporate a silver lining that I think is Steve's silver lining into my answer, which is you've got this tremendous resource of workforce that's leaving the federal government right now. And that leads into my silver lining, which is, if you can manage the resources, if you can either, refocus or hire some great people from the federal government to pay attention to these conflicts, I think most of the time there's going to be a light at the end of the tunnel. Now, there is this uncertainty, and it's probably at its height about now. Maybe it's at a plateau. I hope it's going to start waning. Where there is more certainty, there's more guidance, there's more, more litigation is working its way through courts, and we're getting decisions about, what is or is not violative of, for example, federal civil rights law on DEI programs. There's more guidance on that now than there was 3 months ago, but it's still not quite there. But at least it's heading in the right direction. And so I think focusing on this issue, being aware of this issue, thinking about these hot topics that I had on my list as being particular areas to pay attention to, there's a resolution for many of these issues. I don't want to sugarcoat it, though. There are going to be a lot of risks where you have to make a decision, whether it's the impossible decision of not taking federal money, or the impossible decision of complying with your state law when you're not sure if you're going to be in violation of a federal law. There are going to be those tough questions, and I guess one of those resources is getting the lawyers involved.
Can I jump in?
Please do, yeah.
So as Aaron said, we had talked about this topic, but I want to pose this as clearly as I can to you. This is a human capital opportunity for you. I'm going to give you a single anecdote. At George Washington, we're one of the 3 largest law schools in the country. Year in and year out, we put more students in federal service than any law school in the country. Between January 1 of this year and March, 50 of our top graduating students lost government jobs that they thought they were going to be getting with the federal government. So, from a capacity standpoint, there are unbelievably talented people, incredibly well schooled in procurement, who have historically not looked to you for job opportunities. And again, I don't want to do the federal government, I'm from Washington and I'm an arrogant, condescending puke, even if you think I am. But let me be empirically clear. The federal government has done a much better job at a macro level than the states, hiring more people, hiring them at higher credentials, often with business school degrees, giving them more training, and getting them more certifications at the highest level of procurement expertise. These people are losing their jobs in droves, and they would love the opportunity to do meaningful work for you, and that's what they're used to. And I'm not going to rat them out, but I have a former student in the room that worked at one of the very best agencies in the federal government doing procurement at the highest international levels, whose entire office was gone, and now he's a state procurement official. But trust me, they are out there for you, and people who have generally not been looking for the opportunities you have are going to bring immense talent to you if you're willing to open the doors, consider them, look for them, and bring them in to help you.
Thank you, Steve. Eric, you have the impossible task now in the last minute. Takeaways, but can you come up with a new silver lining? Because we've hit on the same one twice here, so.
Yeah, I can. This is another opportunity-based one, and the way that I see this is procurement is really, really hard, and I don't need to tell all of you that. You all know that, of course, and it can be sometimes made harder by. I practice in a lot of states around the country, and so I've seen a lot of state procurement codes, I've seen a lot of state procurement regulations, and many of them are, unfortunately for the state procurement officials, ineffectual for the modern day procurement, right? And so this is a big reason why, for example, the model procurement code plan is being put into place right now. But this is also just given all the changes in federal law, given the changes in federal policy, and the revolutionary FAR overhaul, as we've talked about a few times. This is a great opportunity for states to just take a second look at their procurement regulations, and if possible, your procurement code. But obviously, that's out of your hands. And just to take a second look and say, does this really fit what I need to do today, or is this just causing me more frustration than it really needs to? Unfortunately, not every procurement is buying gravel by the ton, right? Like if it was, that would be wonderful, and everyone's jobs would be much simpler. But that's just not how it is. But many procurement codes are written with that type of somewhat outdated but still useful acquisition in mind, right? So this is just another opportunity where you can make your own lives easier, both through the opportunity of hiring more people and by considering the current status of varying state procurement regulations to try to improve those a little bit and just update and modernize them.
So thank you very much to our panel. Now we're at the part that I like best. The last 8-9 minutes we have left here. Interested in your questions. We've tried to frame our whole conversation around questions that came from NASPO, but we'd be interested in your questions today as you've listened to what we had to say. Megan, were there any that came in over the app?
There are. However, if you want to stand up and ask a question, you'll get priority.
Ooh,
Does anyone want to stand up and ask a question?
okay.
Oh, we got one over here,
Please,
Chelsea.
Please.
It better be a good one.
That's right.
Uh-oh,
that's
Chelsea.
right. No pressure.
Well, mine is hopefully just a really practical question. So you mentioned as one of the silver linings is the federal talent that we now have access to. What are the practical ways we can reach that talent outside of just like posting on our own like internal websites? Like how do where are the channels we can reach out to entice those individuals and find
Steve,
them?
Aaron, you please go ahead.
Yeah, so I don't mind offering you a couple. First, email us. I mean, I don't want to tell you how big our LinkedIn network is, but it's huge. And, thousands and thousands of people pick that up. Like NASPO, but a little bit different. If you're not familiar with NCMA, the National Contract Management Association, that is the federal professional organization for many in our field. But I also think you'll be surprised how quickly people will find them with searches. But again, I think that sharing on social media is a great way to start, and resharing. So, but again, who you're connected to really helps. Those are the two I would start with.
Yeah, NCMA is a great option, particularly for procurement professionals. On the lawyer side, I'd say the public contract law section is a great place to go. There are a lot of government lawyers who are members of that group, and we've seen many. We have the section has a program next week, and I could give you 5 or 6 names just of people who were speakers on that and are no longer speakers because they've lost their federal jobs. I mean, the numbers are pretty incredible.
Excellent.
May I just jump in as well? My name is Ludmila Bond. I'm one of those people who lost their jobs in the federal government. I used to be representing the agency that doesn't exist anymore in the Federal Acquisition Regulation revision. So I can be a resource for anybody looking for federal talent. My name is easy to remember, Ms. Bond. So,
Excellent.
and I actually wanted to jump to see if you'll be interested in answering my question. So I'm looking for, and coming from the federal perspective where you had a lot of agencies working together and trying to establish uniform requirements which are easier for the public to manage and absorb. I'm kind of curious, are there mechanisms here that we can tap into each other, states dealing with the same issues, more on the consolidated manner rather than just one at a time? I know our challenges are different, but also very similar.
I don't mind saying, at least from my perspective, I think NASPO's come a long way over the years. I mean, I think it could be stronger, but what we saw with the evolution of the Model Procurement Code, it seems like there's a much more cohesive voice. I think the internet has actually really helped us. We can joke all we want about the way that we did this in the past. I think to Aaron's point, and you heard it earlier on the prior panel, I think the ABA section of public contract law is being far more inclusive on state and local these days. But again, I think this is one of those things where things are moving in the right direction, but it takes a long time.
University of Dayton Law School is starting up a great program.
Thank you. Thank you. Appreciate the promotion there. That's great.
At least they're trying to.
Nothing more to add. Great answers.
Okay, yeah. Any other questions? We're down to 4 minutes.
What did Megan have in the queue? You have any good
Yeah, I'll
ones?
take one from the app, a very popular question. Could you talk more about updates to the micro purchase thresholds referenced, which will affect 90% of purchasing?
Okay, so real quick, getting the Wayback Machine back in the 1990s. For the old folks, we grew up with something called an impress fund, which was basically petty cash in a box that you kept in the office. There were some rules on that. But in the 1990s, we introduced the micro purchase threshold at $2,000, which at the time was the price for a laptop computer. And the theory is we were also broadening use of the government charge card. The theory was it would reduce burdens on the acquisition community if we didn't have full and open competition when you went to buy a commercial item that you could buy COTS commercial off the shelf. $2,000 late 1990s. That was indexed for inflation, but over the last couple of decades, the GSA has been advocating for a raising of the micro purchase threshold to dramatic levels because it fundamentally changes the burden on acquisition professionals. The theory being, take your most trained and experienced people, put them on big procurements, and let normal people make the kind of decisions you make every day on Amazon when you're buying commercial off the shelf. Well, it started to inch up, but you don't need to be a rocket scientist to figure out that there's a big difference between $2,000 and $15,000, particularly when we're talking about commercial services. And I do realize that the rules prohibit disaggregation for the purposes of staying under the threshold, but we know it's a fact of life, and stay with me, there's basically no oversight in any meaningful capacity under the micro purchase threshold. So in effect, what that means is the smaller, higher volume acquisition burden is basically evaporating and turning into the Wild West, which in many ways is consistent with commercial practice, but not exactly the kind of thing that you'd want to think about if you were part of the oversight community. But in terms of the workforce, this will dramatically change day-to-day work at the federal level, and the question is, as a trend, whether the states will go in the same direction.
Excellent. Any other
I
comments?
think there was a question in the back.
Okay.
Yes, I have a question. Thank you. And I know you don't have much time. So with the redo of the FAR, last NASPO Law Institute, we had a presentation on agile procurement. So how applicable is the agile procurement to state government? Is that something we should be exploring?
Eric, Aaron, one of you want to take that?
I don't mind saying that if you're not thinking about agile and innovative procurement, I don't know why we're here, okay? So don't take that in the pejorative, but I think that the powers that be would tell you that much of the revolutionary FAR overhaul is to empower flexibility and innovation. Whether that's all talk as opposed to action, that's another story. But many of the people who were involved in the most successful innovation laboratories are actually part of the inner circle that is pushing the revolutionary FAR overhaul. But I do think that most acquisition reformers want you to be thinking about innovative practices. Whether you decide to use something like other transactions at the federal level or not is another story. But the idea is we don't want acquisition professionals who think their job is to just follow the rules. Public bid opening, low price wins, follow the rules, don't think creatively. We want people to think in terms of business decisions that benefit the public customer. That's what we want.
Thank you. With that, we have 30 seconds left. Can we give them back their 30 seconds, or is there something else we should take?
Well,
Megan?
I think we have a good question to end on.
Okay, let's do it.
So we often struggle with issuing guidance to stakeholders with ever-changing federal directives. How do you balance keeping state departments and vendors informed while avoiding mass confusion and increased devotion of time and energy to these issues?
Look like you might have something to say.
Oh, I just was appreciating the difficulty of the issue. That was oh yeah.
I was trying not to respond by just saying, you don't, which is my visceral reaction. Yeah, no, I think that's the kind of the thing, hits the
Right.
core of why we did this panel to begin with, which is, there is no easy solution. We think more resources focusing on this issue is a step in the right direction. It will get better as there's more guidance on some of the, the really sea changes in policy that have led to sea changes in law and at least in enforcement from the federal government in the last 9 months. I mean, I'm not saying things aren't going to be chaotic and different over the next 3+ years, but it won't be, it'll be 3+ years after this 9 months as opposed to 9 months after the prior administration, which was a much more dramatic change. So I think that the level of guidance, the level of uncertainty, the level of guidance will go up, the level of uncertainty will go down, but there will need to be a focus on this.
Right, and the best advice I can give is just to it's to share whatever you learn with your teammates, because the best way that I've learned is from my colleagues who, when they see a Law 360 article about something, they fire it around to the team, and that is unbelievably helpful. Even if we're all actually getting the same newsletter every morning, sometimes I don't see everything that's on there. So if one of my teammates shoots it over and says, hey, look at this highlighted article, take 30 seconds to look at it, or if you can summarize it for your teammates, even better. That is the best way I've found to just try to distill all of the things that are happening all at once, the everything everywhere all at once, is to work with your teammates, work with your stakeholders, keep an open line of communication. It's so much more helpful than you think to give others just brief summaries of what you've been keeping up on.
I actually love this as a closing point. I love to tell people that acquisition is ultimately a team sport. We're all in this together. And being at a place like this and treating this as a community and sharing your experiences and learning together, that's the way we all improve. None of us are alone in this, but again, thanks for all you do on a day-to-day basis.
Thank you to our panel for an excellent discussion and your great questions. This has been a pleasure.
Thank you all.